Good morning, everybody. We're just going to give everyone a few minutes to join. We've just gone live for this episode of the Burr Morning Show. So if you're just now joining us, stay tuned. We're going to give everybody just a few minutes to log on, and then we'll get started. Thanks. All right, guys, let's go ahead and kick things off here. Thank you for joining us this morning on this episode of the Burr Morning Show. Today, we are going to be talking about workplace accommodations, and we are going to be focusing in particular on issues, cases, EEOC enforcement actions that have come out post-COVID. From my experience, this is something we're seeing more and more. So thank you so much for joining us today, and we're going to dive right into it. My name is Emily Mack. I am a partner in Nashville's in the Burr and Foreman Nashville office in the employment group, and I am joined today by Savannah McCabe, who's an associate in our labor and employment group. So I'm excited to talk about this, Savannah. I don't know how you feel, but this is definitely one of the things that I am seeing more and more clients calling about. This continues to be a really prevalent issue for HR. I also think that employees are getting more sophisticated when it comes to requesting accommodations. They are aware of their rights. They are looking for us to slip up. And these issues are getting more and more gnarly, I think, post-COVID. And we're also, I know today, going to touch on the new Pregnancy Fairness Workplace Act, which is just, adds a whole nother, level of complexity to analyzing these things. What do you think?
Yeah. These things are a hot topic now, especially with the prevalence of mental health issues coming out of COVID. And like you mentioned, employees are getting more sophisticated and the law is expanding as well. And the EEOC is targeting employers for any type of bias toward mental health issues and some other new prevalent concerns that we'll touch on today. So yeah, I'm glad we're covering this.
All right, well, let's get into it. First off, just to kind of, it's early. Some people are still on their first cup of coffee. So just want to give a quick kind of ADA refresher. Although I'm sure most of you listening in are familiar with the Americans with Disabilities Act, particularly as it was amended in 2008. And so we know that under that act, discrimination against qualified individuals with disabilities is prohibited with respect to any terms and conditions of employment. So training, pay, termination, hiring, promotions, other types of employment actions. But you can also be, held liable under the ADA as a standalone cause of action for failing to reasonably accommodate a qualified individual if the individual has an actual impairment that substantially limits a major activity. So we know under the ADA there's different types of protected classes, and Savannah, I think you're going to talk on those. But, when we deal with claims for failing to reasonably accommodate, the individual has to have an actual disability, not be regarded as having a disability. And so our discussion this morning is really going to focus around reasonable accommodations, how those claims are making their way through the courts, how the EEOC is viewing them, and focusing on the mental health issues that we're seeing, as well as the remote work requests that we're seeing more and more. You want to go over the different types of disabilities, Savannah?
Yeah, absolutely. So what is a disability? Now, it's not always going to be your responsibility as an employer to make that determination. Some disabilities are obvious. Some will require documentation from a medical provider or other provider demonstrating how a major life activity is impacted. But we more so want to make you aware of how broad and expansive the definition of disability is under the ADA. So textbook definition, disability is a physical or mental impairment that substantially limits a major life activity. So it's not just any type of impairment, not just any type of illness. It's got to substantially limit a major life activity, which major life activities are pretty expansively interpreted as well. I mean, it's anything from walking, talking, sitting, standing, performing your job, focusing, concentrating. It's pretty expansive. Also, what could be considered a disability under the Act is a record of impairment that substantially limited a major life activity while it was active. So a former disability. And like Emily said, today we're focusing on reasonable accommodation. So our focus is just on an active current impairment that needs to be accommodated or may not need to be accommodated. But just as a refresher for you, a company can still face discrimination or retaliation liability based on a record of impairment or knowing that an employee had a disability in the past. And also falling under that second category is being regarded as having an impairment, whether or not the impairment is regarded as substantially limiting or whether or not the impairment exists. So that's something to be aware of just for discrimination purposes. I think a theme of our presentation today, and really anytime you deal with the ADA, is that there aren't many bright line rules. It's a very fact specific and case by case, circumstance specific area. So we've included down here some examples and asked, are these disabilities? Well, the real overarching answer is it depends. They all could be, they all couldn't be. So just to go through diabetes, diabetes is almost often or is almost always considered a disability. The flu, so things that are typically things that are minor or temporary or like an isolated illness typically aren't considered a disability, even if it substantially limits a major life activity for like a day or 2 days. A disability contemplates something that needs to be accommodated on a longer term. But that being said, things that are short term could be considered a disability if they have long-term complications. So a good example of that is long COVID. Something that, you might have COVID once, you might recuperate, that might not have been a disability, but we're seeing several individuals report long COVID, which is a more long-standing disruption into their life that might need to be accommodated. Something like surviving skin cancer 10 years earlier, that if it's not active currently and it's not requiring an accommodation currently based on what the employee reports to you and what their medical provider reports to you, it's probably not a disability for accommodation purposes. However, things like this are important to watch out for in the record of impairment category. The employee has no medical ailments, but the employer thinks the employee is depressed. rights under the ADA and an employee's right to an accommodation is triggered by the employee requesting an accommodation. We'll get into that. That doesn't have to be a specific request, and we'll get into that. But so under this example, as it's worded, no medical ailments, but employer thinks the employee is depressed, that wouldn't be something warranting an accommodation until and if the employee gave some kind of indication that they are struggling with clinical depression and it's disrupting their work or another major life activity. Migraines once every year, that's probably not a disability, probably one of those isolated examples. But again, if that turns into a more longstanding issue, then an accommodation might need to be considered. A recovering alcoholic, illegal drug use, obviously alcohol isn't illegal, but just on the drug and alcohol note in general, illegal drug use in and of itself is never a disability, but recovering can be considered a disability if it substantially limits a major life activity. So that gets to participating in a drug treatment rehabilitation program. If the employee is reporting the limitation on a major life activity or their provider is, then yes, that could be considered a disability.
So I think if we're looking at this from the aspect of best practices, HR, it sounds like, again, I think that ever since the 2008 amendments were passed, the best practice is assume disability, attempt accommodation for these things, right? Particularly if an employee, as you know, in all of these cases, if someone's requesting an accommodation, then we have the right as the employer to ask that person for medical documentation that substantiates it. So long as the person that says they have diabetes actually has diabetes and comes forward with the medical documentation to support it, or needs, maybe they need a week off because they've had a bad case of the flu, granting that unpaid leave, you're going to be better off doing that than the Congress has said we don't want employers in the position of determining whether or not something qualifies as a disability. We're better off to, go through what you're going to talk about next, Savannah, which is the interactive process, right? And determine if accommodations can be made for the condition.
Yeah, absolutely. So what do you do with an employee with a disability? Like Emily said, the obligation is to make a reasonable accommodation that allows them to perform essential functions of their role. If there is no accommodation that would allow them to perform the essential functions of their role, then they're not covered under the ADA. The ADA only captures those employees with a disability who can still perform the role with an accommodation. So that's where the reasonable accommodation obligation comes from. Employers are obligated under the Act to engage in what's called the interactive process, which is an exchange and a back and forth between the employer and the employee to discuss the limitations that the employee has and arrive at a reasonable accommodation. This is something that, and it's often a pitfall for employers, is, not engaging in the interactive process at all, just assuming that, what a reasonable accommodation is because it was good for maybe another employee with a similar disability, not engaging in the interactive process enough. But this does have to be an exchange with the employee to determine what's reasonable. And that's why it's important that management and supervisors in an organization are trained to recognize the need for an accommodation. So the employer's obligation to engage in the interactive process, which, like Emily said, the employer should err on the side of engaging in the interactive process anytime there's a suggestion of a need for an accommodation, is triggered once the employer is on notice. So how do you know if you're on notice? There aren't any magic words. Employees are not required to say, I need an accommodation under the ADA. Definitely not a written requirement. They're not required to send you an email. In recent years, requests can be made by a third person. So an employer may be placed on notice by a spouse, a family member of the employee, someone they reside with. A request can be made at any time. So even if an employee was just accommodated, or even if their FMLA leave just ended, it's important to be on the lookout for requests. And that's why documentation is important. Employers are allowed to set up a documentation requirement with a formal accommodation request system, so that they have a paper trail, and so that it's clear when the notice period is started. But even in the presence of, a handbook policy that requires employees to submit a formal written request for accommodation, the employer could still be on notice before that time. And that's why also down here, excessive absences should be documented and HR should be notified, because even if you're noticing a pattern, even if the employee hasn't expressly indicated the need for an accommodation, it would be worth putting into writing that they haven't expressed that. I mean, if it's starting to look like they might need an accommodation, it's best to confirm with them, hey, you haven't indicated that you're struggling with anything that has impacted your work.
I think one of the common things that comes up in this area is different managers doing different things. And so one manager a lot of times this is why training becomes so important, because your first line supervisors are often the ones that are going to be receiving these types of requests and may not even know it. Someone may come to them and say, hey, I have therapy, therapy or physical therapy, every Friday morning. Can I come in, late? And that supervisor just goes ahead and approves that without involving HR. Well, that's a request for an accommodation, and that needs to be routed. We have the right and should be in those situations asking for medical documentation to support the request, and making sure that we are handling accommodations in a uniform and consistent way, so that because what will happen is then if we are not doing that, it becomes a disparate treatment claim. If one employee's approved something informally through their manager and then someone else requests something and it's denied, that can lead to issues as well. So not only, and with excessive absences in particular, this is somewhere where it comes up, where the manager kind of allows it and doesn't document it on the front end. And then when it becomes time where we want to take an adverse employment action, we find out that there's some type of kind of accommodation that's been involved that we haven't gotten the proper documentation for. And now it's difficult to go ahead and take action at that point. So all excellent points, just about, again, kind of the reminder that as we see these issues come up, when it's brought to HR's attention, normally HR knows how to respond, how to request the medical documentation. And another point here is that this is all about going through the process. What Savannah is absolutely right, that the pitfall here ends up being employee makes a request for X, company predetermines that would not be reasonable, and we end up kind of jumping the gun and denying a request without going through the process. This is very much require the employee to come forward with the medical documentation. Look at the medical documentation. Isn't sufficient. If it isn't, that in and of itself is a basis to deny the request temporarily or require the employee to go back and obtain sufficient documentation, right? And if we follow this process, we make it more difficult for an employee to claim that we've just failed to reasonably accommodate them, because they do have the burden to come up with the documentation needed to support what they're asking for. And we're going to talk more later on today about some kind of practical strategies, how this comes up, how do you evaluate it as an HR professional. So, again, I said that was our ADA refresher. We're going to switch gears now and talk about two issues in particular that I think employers are really wrestling with post-pandemic, okay? Remote work and mental health. These are huge issues that, really we were all grappling with, especially because, prior to COVID, a lot of the courts and the circuit courts had said, that predictable, punctual attendance is an essential job function for any job. And courts were very much sided with employers, particularly on requests for remote work, and on the employer's judgment that in office is important and is an essential job function and is not something that we can accommodate. It was one of the very few areas, kind of like indefinite leave, where we knew in an ADA scenario, the courts were on the side of the employer, and we felt good about giving advice on denying a request for remote work, because of the precedent that we had kind of across the courts. Well, COVID occurs. We know that everybody was able to kind of pivot to remote work in, a 2-week, 4-week period of time, and things are different now. So what we're starting to see now, a few years post-COVID, is some of the first district court decisions and even circuit court decisions that involve this issue. And so, that's how the advice that we give in every scenario, and keeping in mind that these are all incredibly fact-specific cases, is good to know. But this is where we draw that guidance and advice from, is these decisions. So we're going to take a look at some of those now, first dealing with remote work. So where are we at with this? The EEOC has come out in its guidance and said, that employers are not automatically required to allow remote work as an accommodation post-pandemic. All right. So if you're an HR professional, you're thinking, this is great. EEOC says we're good, business as usual. Not so much. Okay. We know that the EEOC's guidance is not binding. And, the reality is that there's been a lot of litigation that surrounds this issue. And in some cases, factual disputes are preventing courts from granting summary judgment on this issue. What does that mean for you as an employer? It means that these types of cases, you're going to be going to a jury who's going to determine, should the employee have been allowed remote work or not? Was it an essential job function? That is a risky roll of the dice and an expensive endeavor if you're in the position of an employer. So, some of the recent cases around this, the first listed here, EEOC versus ISS Facility Services. This one is an EEOC settlement, where the EEOC actually filed suit against an employer after it refused to let someone that was high risk work part-time. Now, the important thing about this case is that others were being allowed to work part-time. And, because the case was a settlement, we don't have a lot of information about who those other individuals were, but we know that they were in the same position as this individual who requested to work part-time from home. And this is the kind of thing that is getting the attention of the EEOC right now. And so it's really important to make sure, that if you get a request, from an employee and we're denying it, that we've looked to make sure that others that are substantially or similarly situated to that employee aren't being allowed to do the same exact thing. If they're being allowed to work from home and they're not disabled, and someone with a disability is requesting to work it, we better have a really good reason to say that that's an essential job function if you have similarly situated individuals that are non-disabled that are being allowed to work from home. Here's the other things I often hear. Well, this person has more tenure, that we trust this person, whereas the disabled person is a new hire. And so, we can't trust that they'll be able to work from home. Those are performance issues. Those are metrics that we can establish. We can establish check-ins with the supervisor. That is not, to me, a good reason normally to deny a remote work request. Now, if they're not performing, because we know that we can hold them to the same standards as an employee, if they're not performing while working from home, let's address that from a counseling and a performance standpoint and document it. But don't jump the gun and deny the request because we think they're new and we can't trust them and they won't be able to do a good job from home. That's a prejudgment on our part that, that will lead, I think, to an easy claim that we failed to accommodate them because, the question is it an essential job function? No, right? The second case here is a Fifth Circuit case, Montague versus USPS. In this instance, the district court held in favor of the employer, right? So it granted summary judgment on the ADA failure to accommodate claim. This was an employee who wanted to work from home in the mornings and come into the office in the afternoons. She was a PR employee who worked for the Postal Service. And the district court said, listen, based on the Fifth Circuit's prior precedent, we're going, work if an employer says that it's important to be in the office, then we're going to defer to that. Well, this employee had come up with declarations and affidavits from former employees in different areas who said they worked remotely even before COVID. And there was really no good reason that was put forward by the employer for, for justifying why she couldn't do the essential job functions at home, right? And so, this was one where the Fifth Circuit reversed the district court's grant of summary judgment, getting rid of the case, and they had to go back and go to trial, or likely the case settled at some point after trial. So that's another recent one, right, just issued this year, where we're seeing that the Fifth Circuit recognized, yes, that was the old rule, but now, post-pandemic, we need to really be looking at this and analyzing it more carefully. And is this really an essential job function?
Yeah, so we've also included a couple of cases here where the employer did win on proving that being in the office was an essential function. So that could still be possible. One of these cases out of the 10th Circuit is from 2021. One of the cases, Kinney versus St. Mary Health from the 7th Circuit, is from this year. So like we've said all along, ADA issues are case by case specific, very fact involved. Employers can still prove that being on site is an essential function, but I want to highlight how much these employers had to prove in these cases and how detailed it was. Also, both of these cases involve mental health issues, so there's a lot of crossover between the two major post-COVID concerns. In Brown versus Austin, the plaintiff was a fraud investigator for the Department of Defense. He took FMLA leave for PTSD. When he came back, he requested to work from home to avoid the stress of an office, which triggered his PTSD. The employer denied that as unreasonable and offered other accommodations as well as you're required through engaging in the interactive process. The employer offered that he, have an office with a closed door by himself. The employer tried to provide him with headphones and earbuds, a few other accommodations, but the court sided with the employer here, and that was because as an investigator, he needed access to voluminous physical case files that couldn't be transferred home or copied. In the interactive process, he tried to ask the employer if an assistant or a secretarial employee could scan the files that he needs and send them to him day by day. Well, the employer engaged in a pretty thorough cost-benefit analysis to show how much work that would take away from a secretarial employee when she needed to be doing other things for others. So the employer won here, like I said, but it had to be prepared to prove why this worker needed to be in the office and why that was an essential function. And the worker denied the accommodations provided, and working from home was not reasonable. Similarly, in Kinney versus St. Mary's Health, the employer here was a director of imaging services. So she was a supervisor of other employees on the imaging team. She had anxiety and requested to work remotely, and her doctor supported this with medical documentation. because her anxiety was exacerbated by wearing a mask. This was during COVID, so it was the workplace health and safety policy that employees wear a mask. Here, the employer also successfully proved that in-person work was an essential function of her job, and the employer won. But again, the employer had to prove with detailed evidence that she was responsible for obviously supervising her subordinates and acting as a liaison with other department heads. The employer had to show essentially how much of her job functioned on premises. So, like, how many interactions were taking place, email trails showing, kind of proving a negative, proving that business wasn't getting done over email. Showing the nature of the job. I mean, these are imaging services specialists at a hospital, so they're on the move, actually tending to patients. But the employer really had to prove that with detail.
And in the Kinney case too, she was responsible for all this equipment. And she admitted, in her deposition that basically she had to rely on other individuals to do that because if she was working from home full time, she wasn't going to be able to do that. And I think that was another important factor that went into that, as well as I think she supervised like 140 employees, and they had complained about her not being present, right? And how that was impacting them. And that was another factor that the court hit on a few times. I think the takeaway with all of these cases, again, is that these are highly fact specific. You can't kind of draw any bright line rules from any of these that allow you to kind of, be able to make this determination. It's still a case by case determination, but one other thing that is important to note is, what do these courts look at when they're analyzing? If the employer says we're denying an accommodation because it would eliminate an essential job function, which in the remote cases is usually being on site, right? Number one, better be in your job description, because that's one of the things that we're looking at. They're going to look at, is it in the job description? What does the employer say about it? What have other employees in the incumbent's, role been required to do? What has their history been? That was an issue in the Postal Service case, was that other employees who had performed the job in the past had been allowed to work remotely, right? And making sure that the reasons for that, and if it is essential, it's listed, and those job descriptions are up to date. Again, whether the job has ever successfully been performed remotely, and you need to be able to articulate what changed, if it has in the past, what has changed from now, and then also the language of your remote work policies. If it's available to employees, then you're going to be hard pressed to prove, that it's an unreasonable accommodation. So keep all of that in mind, in talking about this, because these issues are not going anywhere. In my opinion, I think that this, we have a 25% rise in anxiety and depression diagnoses since the COVID pandemic. And I will say that, this year I have seen, just, in getting calls from clients, more and more of these issues: ADHD, depression, anxiety. These are things that people that before we thought of accommodations as being for physical disabilities, things with finite end dates. How do you approve leave when someone's going to be recovering from surgery? That's a lot easier to do than handling these mental health disorders, right? Because they are usually not going anywhere. They might be treatable or manageable, but it's harder to come up with accommodations to deal with them. And it's also harder to kind of understand when you're granting things like, leaves of absences, when there's going to be an end date, when does this become a request for indefinite leave, right? So, again, for things like ADHD, PTSD, some of the accommodations can include reminders of tasks, due dates, quieter work environment, frequent breaks. Remote work is a common thing, and other things. But these are all going to be very position and work environment specific determinations. And remember, again, the important thing to do here is to not prejudge, not predetermine, really engage in that interactive process. And I think a lot of times it's kind of a box that we tend to check, where we sit down and we ask the employee what they need, and then we say, okay, we'll get back to you. I think as HR professionals now more than ever, when we're talking about things like ADHD, when we're talking about things like depression, what would we be able to do that would support you? And how, if you're asking for remote work, how would that be? Why does that help you be able to better perform these things, right? Because you may experience that at home just as much as you would at the office. And if they're not able to articulate reasons for that, then that is something that can factor in. Had a recent client with someone with ADHD, and they already had lists and checklists, and he got into that conversation. He couldn't offer anything. He was like, really, there's nothing you can do to help me with this more than what you're already doing. And so it helped us be able to kind of, resolve that and say, listen, if something changes, if you think of something, but at this point, you've kind of told us that you have a condition, yet you haven't, suggested that there even is a reasonable accommodation that you need in order to perform the essential functions of your job. We were able to continue going down the PIP path with that individual, and ultimately separate them. But it's because we asked those questions and really engaged in that back and forth in the interactive process that allowed us to be able to get there. We know, again, that employees are not, entitled to their preferred accommodation. They are entitled to a reasonable accommodation. So, don't just accept that if they're wanting remote work and that's something that's really problematic for you as an employer, that that's what they necessarily have to have. And only through those kind of back and forth conversations where you ask targeted questions are you going to be able to get the information you need to make the determination as to whether or not, maybe they say, well, I need to have closer access to the bathroom. Okay, well, we can move your office, right? I mean, there's things that can come out of that conversation that would put you in a better position to be able to, if you're going to be denying it, be able to articulate why that is the case. Or perhaps look at other accommodations that aren't as burdensome on the business.
Absolutely. So we've included a few cases here, again, where the EEOC has sued a company based on mental health disability issues. And these are, again, all cases where the company has settled with the EEOC. So there's not a concrete ruling from a court here to really give us any guidance. But we include this to show that mental health accommodation is a focus of the EEOC's litigation efforts, and the kind of fact scenarios that they're going after, which may seem commonplace. So, for example, in EEOC versus Ranus Management, a case out of Georgia from last year, the company ended up settling for $250,000 after it terminated a depressed employee. So the employee actually was granted time off to recuperate from depression. So the employer had given that accommodation. But when he returned, he actually presented a return to work clearance from his doctor, but wasn't permitted to work because the company said he, quote, could not be trusted to perform his job. So, again, this is more of a discrimination case because it identified an animus toward mental illness as a disability, but even after he returned, the company was obligated to engage with him in the interactive process, and certainly it wasn't advisable to take an adverse employment action. And an EEOC spokesperson with respect to this Ranus case actually said, with respect to the EEOC's goals, the EEOC is committed to seeking relief for workers who are harmed by employers who discriminate because of biases and fear. There's not more context provided with that, but it indicates that the EEOC sees the employer arena as maybe hostile toward mental illness, making it a focus of their litigation efforts. Similarly, in EEOC versus Hollingsworth Richards out of Louisiana, the employer settled for $100,000 with the EEOC after an employee with ADHD took prescribed stimulants that were lawfully prescribed by her doctor. And she was told to stop taking the medication and required to take a drug test. And she was actually terminated before the results of the drug test came back, showing an animus toward ADHD by the employer. And again, these are all just allegations that the EEOC put forth in a lawsuit, and it was settled. So we don't have any rulings here. But again, these are just fact patterns that we've seen. Finally, the EEOC versus Lonza America LLC out of Tennessee. The employer settled for $150,000 after an employee who was a recovering opioid addict, so not currently actually unlawfully using opioids, still tested positive for a controlled substance because he was using a legally prescribed medication to help him with recovery from opioid addiction. So the employer essentially saw that positive drug test and didn't engage with him to understand why, and he was terminated. But yeah, again, this is just to show the EEOC's focus on this issue.
All right, we're gonna step up kind of some of these slides here because we still have some good stuff to get to, but are kind of, running short on time here. So, and again, this presentation is being recorded, and I think we can make it available to everyone too. So if I hit any of this quickly, you can go back to it. But one of the questions I get a lot is, who's an appropriate professional? People will send in ADA paperwork that's been completed by a social worker, by a therapist, by a PA, and one thing we have to remember is that, you do have the right to request sufficient medical documentation, but the appropriate professional to provide an opinion depends on the disability and the type of limitations. If you are seeking an accommodation for cancer, you cannot turn in a note from a chiropractor, right? There has to be alignment, right? But it doesn't have to be an MD that is providing these. And especially with the mental health concerns that we're seeing, oftentimes it isn't. It's a social worker, another licensed mental health professional. You do have the right to require that it's a licensed mental health professional, right? Not a pastor or someone like that. That's providing this paperwork, but be cognizant of the fact that it's a broad spectrum, and so long as the individual appears to have appropriate credentials, with respect to the area that they are opining in, this is one of the areas that I give deference to. Let's kind of assume that this person is qualified to be doing this, as long as it doesn't appear to be someone who's made up or something like that, and instead focus on are they really providing the information that is needed to give us an idea of the major life activities that are impacted by the impairment, and the limitations, the functional limitations, and the severity of those, right? It needs to be congruent to support the requests that they're asking for. They cannot just say, I need to work remotely because I have depression. What is it about your depression that is limiting your ability to perform the essential functions? And how are you going to be able to do that better at home than you would be in the office? Right? So that's really critical when you're looking at sufficient documentation, is not so much who's filling it out, but what does it say? So we're going to come back, wrap up with kind of, Savannah's going to hit Pregnant Workers Fairness Act real quick, because that's something that I am terrified about, frankly, and we all should be, because this just takes our accommodation world and blows it up, and then end with also some practical guidance as well. But if you have questions, we'll try to get to them, put them in the Q&A, and we'll try to kind of hit on those as well.
Yeah, absolutely. So, like Emily said, the Pregnant Workers Fairness Act, that's a new federal employment law that went into effect of June of this year. It applies to employers with at least 15 employees. So most employers fall under it. Just as a contrast, under the ADA, pregnancy alone is not considered a disability. The ADA is only implicated for a pregnant person where a medical condition arises out of pregnancy and causes a separate impairment or intensifies pregnancy symptoms, excuse me. But if we want to go ahead to the next slide, here's how this new act amplifies that. The act applies to, quote, known limitations related to pregnancy, which really broadly expands what is considered a disability or here a limitation that needs to be accommodated for a pregnant person. Employers must engage in the interactive process to provide reasonable accommodations for pregnancy itself, childbirth, and related medical conditions. And there is still an undue hardship defense here. So the employer can try to argue that providing an accommodation constitutes an undue hardship and isn't possible. But it really does expand the definition of what needs to be accommodated. And with that said, though, however, the government has issued guidance indicating that accommodations can be pretty simple, like the ability to sit at a workstation, closer parking, more water and restroom breaks, flexible hours. So with that being said, undue burden or undue hardship is a pretty difficult thing for an employer to prove. When an employee who wanted a pregnancy accommodation sues and said, "Oh, well, you didn't give me closer parking," it's not really sensible to defend and explain why that is an undue hardship. However, the most important thing about the Pregnant Workers Fairness Act is that employers cannot require a pregnant worker to take leave as an accommodation, whether paid or unpaid, if another reasonable accommodation is available. So leave is a last resort accommodation, and the employer is going to have to be ready to prove that it really engaged in a substantive interactive process with the employee to walk through other accommodations and essentially determine that they wouldn't work. So that's just the most important thing to keep in mind when dealing with a pregnant employee, that leave is an absolute last resort and really shouldn't be looked at if there are other accommodations at all.
Right. And I think that the scary thing about this to me is the stuff that, like, more water and restroom breaks, that's a no-brainer. I mean, people are doing that. It's I have morning sickness and now I need to work from home for the duration of my pregnancy. And, how do we establish, undue burden in that situation, right? And knowing that person is also then taking leave after. So it's, this is where it's also a scary area, because all we have right now is kind of very broad EEOC guidance that makes this broader than the ADA, I think. We all agree with that. And we don't have any cases that have kind of come out and said we're going to go with the EEOC's guidance or not, because we know that it's not binding. And so I think if you're in a situation where you have a pregnancy accommodation request, it's really important, if you're especially if you're going to be denying or trying to cite undue burden, to be looking at talking with your counsel before you do it, because this is something that we're all trying to kind of evaluate and wrangle. And, again, this is an area where I personally have, for the most part, been telling clients to go ahead and err on the side of accommodation, address performance issues, address, objective things if we need to, but not just simply be denying, request at the outset unless you feel really good and have run that, through your lawyer. We have one question here, which is how this new law interacts with the lack of FMLA coverage for new employees. Are there any protections when a new parent wants or needs to take leave, but their job isn't protected by FMLA? So the good thing, I think, Savannah, about this law, you tell me if I'm wrong, is it may allow a period of short-term leave as a result of childbirth, but not, I mean, are we giving 12 weeks of leave for childbirth under the Pregnant Worker Fairness Act?
I haven't seen anything conclusive about that. And I would also say here, I haven't seen anything conclusive on this front either. But I think the way it's drafted, the provision about leave being a last resort accommodation, tends toward the employee not wanting to take leave, right? Like a pregnant worker wanting to continue working, not wanting to take unpaid leave. I think if the worker requests leave as an accommodation, then it can be considered as part of the interactive process and consideration of any accommodation. But to answer the question, I'm not aware of any entitlement to leave.
There certainly wouldn't be anything, for bonding. The one thing that I think where you may have to consider some leave is for childbirth. There's going to be, whether we look at that from ADA or from the pregnancy, there's going to be an associated period of time immediately following childbirth, where a doctor is going to say, this person, is not released to return to work. Right now, the length of time I think is probably shorter than the 12 weeks, more like 6, perhaps. But it's an open question. And that's what we're going to have to wrestle with. I would certainly try to afford some leave if we know that under the ADA, leave is a potential accommodation. And if you have someone who cannot perform their essential functions of their job due to having just given childbirth, there may be some leave as a last resort that is required, right? Under this new law. The parameters of that, are remain to be kind of defined by the courts. All right, so I think we're going to wrap up here. And if anyone has additional questions, please put them in the Q&A and we'll try to get to them. How do we handle kind of just best practices for handling reasonable accommodations? The job descriptions are critical. I say it every presentation I give because it applies in so many different areas. But making sure those are up to date and that you have them is critical, and that they're accurate. Because if you're going to claim something is an essential job function and it is not listed in your job description itself, if you're claiming something's an essential job function and it's not listed in your job description, the courts are going to scrutinize that. It's going to be very difficult for you to establish that it is. Consistency is key. Consistency, treating similarly situated individuals, consistently, that are doing similar positions. That you may have to look at different departments and similar positions, right? And making sure the managers are treating people the same is very important in this area. And then engaging in this good faith discussion. I talked about that earlier. You want to it shouldn't be a one-way dialogue. They request this, you say, we'll evaluate that and get back to you. Why do you need that? How would that help you? Are there other things that could help you? Can you explain to me, how your ADHD impacts your ability to do your job specifically, and what can the company do to make this easier for you? Make the employee articulate these things. It is their obligation to request the reasonable accommodation. They cannot just say, I have depression, I have ADHD, and I need a reasonable accommodation. What do you need? And then let's dig into why that is the case and how it would enable them to perform the essential functions of their job. Get creative with these things. Modified work hours. That's another one. Where someone doesn't want to work in the morning. Okay, well, can they work at night? Can they work on the weekend? And if that works for their job, for some individuals and some positions, why do we care when they're working, as long as they're working, right? And so it's better than doing reduced schedule if it's a position where they can perform those those tasks outside of the normal work hours, and you still have them at FTE status, right? So consider things like that. And also remember that you're not required to provide the employee's preferred accommodation in all instances. I'm going to hit this because it continues to come up over and over and over again. And we used to say that when there's exhaustion of FMLA leave, additional leave may be required. I'm changing that because I think it is usually required, right? Now, the question is how much? And that's still very much unknown. You know, and there's only a few things that we know in terms of parameters. If it's indefinite, then that's unreasonable. But we better actually have medical documentation that says it's indefinite. And most of the providers now are kind of, you know, don't like to say that, right? They don't like to admit that. So usually what we wind up with is they need another 30 days. They need another 30 days. They need another 30, you know, it's multiple requests. Well, at some point we need to call this doctor and say, you've been saying it's going to be 30 more days for 3 months. You know, why is this 30 days going to be any different? And if they can't explain that to you, or they admit in that conversation that they really don't know, now it's indefinite leave. And now it becomes more reasonable to go ahead and deny another extension of the short-term leave. So multiple extensions of leave may not be reasonable. We know it can't be indefinite, but if someone's asking for, you know, 1 to 3 months, you know, they've already been off for 12 weeks. So you're going to be really hard pressed to say that approving additional leave, you know, is an undue burden, because that's the argument you're going to be making, and it's going to be difficult for you to make that and win. You're much better off approving it. Again, assuming the medical documentation is sufficient that has been provided, and you know, it's not an indefinite request at that point. So just know that it's usually going to be provided. There are going to be some exceptions, but I haven't seen, I don't know that I've seen one yet, really, where I wouldn't recommend approving at least some additional leave under the ADA after this. All right, Savannah, you want to hit our last slide here and close us out?
Yeah, absolutely. And this is really just a repetition of what we've said all morning. ADA accommodation issues are highly fact specific. There are very few bright line rules. It's something that you need to be speaking with the employee about, gathering data about from their medical provider, from them, and talking to counsel about if you have any question whatsoever. Kind of also, like we mentioned earlier, the most common pitfalls we see is predetermining what is a reasonable accommodation prior to the interactive process. Again, the interactive process has to be a back and forth substantive consideration of possible accommodations, of the limitation, where you're asking the employee, why would this help you? Denying a requested accommodation instead of granting and monitoring performance. Accommodations can always be modified with reasoning, obviously, and support. So denying a requested accommodation is always going to potentially land you in litigation, where just granting it and then being able to prove that this didn't work is a great defense. Insufficient job descriptions, we talked about that, and then failing to train managers to both pick up on the need for the interactive process and adhering to accommodations.
All right. Well, thank you for joining us this morning. That concludes this episode of the Burr Morning Show. We hope everyone has a good rest of the year, and stay tuned for new episodes in 2024. I guess there's one more month left of 2023, but you know. All right. Well, thanks so much for joining us, everyone. Have a good morning.